right, we'll call the meeting to order. Thank all of you for being here. I know we got a judge of the day, Judge Stevens. There he is. Okay, good to have you, Judge Lawton Stevens from Athens, Clarke County on the Western Judicial Circuit. Thank you for being with us. And I want to recognize Representative Ramsey for another announcement.
I'd like to recognize a member of our city council in Peachtree City who's up visiting with us today, Cindy Plunkett. She's a wonderful advocate for our community, and despite the fact that she's a Florida Gator, she's also a great attorney. So,
Representative Ramsey, you didn't tell me that bit of information, or I would she would not have been recognized. We're pleased to have you with us. And we're also pleased you sent Representative Ramsey up here to represent Fayette County. And with that, we're going to get started with today's agenda. We've only got two bills, and it's my pleasure to welcome on the first bill now, on Senate Bill 1, the President Pro Tem of the Senate, my former colleague and friend, Senator Eric Johnson of Chatham County.
Thank you, Mr. Chairman, members of the committee. I appreciate your time. I know you all worked hard last night. So I'll be brief. SB 1 was before y'all last year and ended up in rules and didn't make it. We're back this year, and at the suggestion of the chairman, we have changed code sections and I think made it even a better bill. If you remember, SB 1 prevents a sexual predator from intentionally taking a picture of a minor without the parent's consent. That's all it does. It came from a constituent in Richmond Hill, Georgia, in Bryan County that I represent, where a girl was working at a coffee shop, a young girl, and a man came in, took pictures of her chest, and then started showing it to his friends and talking suggestively, made her very uncomfortable, as you can imagine. The man left. They called the police. They tracked him down, and it turned out that he was a convicted sexual predator from Massachusetts, but they couldn't do anything to him. Last year, if you'll remember, the Senate Republican caucus created a website for regular Georgians to access, called Georgia Speaks, to give ideas for legislation, let the people participate in the lawmaking process, and this was one that came through that process. So hence the SB 1 number. We thought it was important to remind our citizens that they're a key part of lawmaking. Since then, there has been a case in California where a man was taking lots of pictures of young children and posting them up on a website, and they couldn't do anything to him. In Cobb County, there was a case where they were taking pictures in a department store of children in compromising positions for the sexual gratification of the photographer. And they couldn't do anything with him, but they ended up getting him on stalking, which means he was doing it repetitively. So this would give law enforcement a tool to prevent sexual predators from taking intentionally. We did intentionally, so you don't take a picture at the Bulldog game and a child happens to be in it. And so we did say intentionally. And at the chairman's suggestion, moved it into what was, in essence, we all passed as 908. So we put it into the sexual predator law, into the restrictions of what they can and cannot do. So that's what's in front of you today, committee.
Thank you, Mr. President Pro Tem. Questions from the committee, Representative Levitas.
Waive, Mr. Chairman.
Thank you for waiving. Representative Abrams.
Yes, I was looking at the substitute. We're working from LC 293366S. Is that the correct version? Yes, can Mr. Johnson, can you explain why you've changed the language that's listed lines 16 through 18 on the House Judiciary sub? My concern is that the language that's currently on line 18, so page 2, line 18 of the substitute that's in front of us now, is a bit expansive as compared to the language that was included on the earlier version that we received. My concern here is that the version that is before us now simply says no individual shall intentionally photograph a minor without the consent of a minor's parent or guardian. And given that we don't have retroactivity in our laws, this will capture a number of men and women who were convicted of crimes that would no longer be considered crimes under the sexual offender registry. For example, someone who was convicted of statutory rape at the age of 16 who happens to take a photograph now of a family who may happen to be taking photographs. This captures folks who are not sexual predators. And my concern is that this is an overly expansive reading of the language. I'm more comfortable with the language that is in the sub that says it shall be unlawful for any person who is required to register as a sexual offender to intentionally photograph a minor for indecent purposes. I think that's a more narrowly tailored approach and does not run the risk of, I think, capturing too many folks that we don't intend to capture with this language.
Yes, ma'am. I think our intent, though, is, and our assumption is if they are a sexual predator, we don't have to worry about what their intent is. They can get the permission of the parent or guardian if it's a family member.
My concern is that we don't have a sexual offender registry that differentiates between sexual predators and those who are convicted of lesser sexual offenses. Our sexual offender registry is fairly expansive, and my concern is that without somehow including in here either a restriction to sexually dangerous predator or the purposes, you're going to capture unintentionally a wider expanse of folks than you intend to capture with this law.
But they are on a sex offender registry list?
They are, but our sexual offender registry list is fairly expansive, and although we've corrected it and we've corrected it going forward, we did not make it retroactive, which means you're going to capture folks who we would now not consider those folks who should be on this registry, but they are on there permanently because we did not retroactively, we didn't retrofit our law earlier.
Like Janarla Wilson?
He would be an example, but I would not use him. I hesitate to raise him, but the folks who are in that class of persons who I do not believe, I would not think are the intended subjects of your law would be captured by this law.
I'm going to have to defer to the attorneys that are on this panel. I'm an architect, so I can't answer the retroactivity or who's on the list or not. My assumption is if they're on that list, then I'd be worried about them taking pictures of minors without their parents' permission.
At the appropriate time, I'd like to be recognized for a motion.
Mr. Chairman, this is, I think, for Legislative Council. Did you do this? Okay. I've got a question about on 18. It says no individual shall intentionally photograph a minor without consent of the minor's parent or guardian. And what I'm wondering about is, okay, I see where you got it from 20 as the qualifying. Is that the threshold for that being? I just want to be sure we're not talking about just any individual. It has to be somebody that's already on the registry, right? Okay, so the whole section's that. Okay, that's all I had. Thank you.
Chairman Franklin.
I would like to be recognized at the proper time.
Okay, we have a couple of sign-ups. Any further questions from members of the committee? We have 3 people that have signed up to speak. I would ask you to, because we have a lot of people that have signed up on the next bill, if you would be very concise in your comments. Sandra Michaels.
Thank you, Chairman Lawson. I did not intend to speak on this bill until I saw the changes. Last year, Senator Johnson very kindly took a lot of testimony and a lot of our work that we spent hours, days working on this language. On page 2, lines 18 through 19, after hearing from a lot of testimony, first of all, there's so many problems with that language. The bill that Senate Bill 1 changed to was a result of all the parties working on it, where it says it shall be, this is not on this new sub, but the old one, it shall be unlawful for any person who is required to register as a sexual offender pursuant to Code Section 42.112 to intentionally photograph a minor for indecent purposes. That's the language we all worked on and agreed on to avoid the problems that are inherent in no individual shall intentionally photograph a minor without the consent of the minor's parent or guardian, which is the old language. You run afoul of what kind of photographs. You've got to have an unlawful intent before you can make it a crime. This as written is not even constitutionally sound because you have to have some kind of bad purpose. And although I understand Senator Johnson felt that if someone's in a predator, a sexually convicted predator, they automatically have unlawful purpose, I don't think the law supports that notion. I would respectfully urge the committee to return the language that was carefully drafted with a number of attorneys' help that was in the substitute to SB 1. I mean, that is the language we all agreed upon, and I thought the Senate agreed upon in Judiciary that was language that avoided a lot of pitfalls. As written, I truly do not believe that could be upheld as a crime. There's no you can't just say someone can't photograph a minor for something else. They got to do it with a bad purpose. And a bunch of examples were given, like people at the playground. If somebody's taking a picture of their daughter on the playground, how can that be a crime unless it was taking a photograph of a person for, I can't remember the sexual words, for sexual pleasure or something like that that's in the code section. So I'm sort of surprised about this change in language when so many folks worked on getting the substitute SB1 written that avoided all the complaints about it. I know you asked me to be brief, but I'm taken aback by this change after so many folks worked on it to make it legally accurate.
Okay, thank you, Ms. Michaels. Sarah Tatachi.
Thank you, Mr. Chairman. I'm Sarah Tatachi with the Southern Center for Human Rights. I'm in a similar position. I wasn't planning on speaking against this bill. By incorporating all the language of House Bill 908, we would have to register our same concerns that we registered when y'all considered that bill, which is that we really do believe that this bill will not be held up by the courts. The Georgia Supreme Court has repeatedly found that renters have property rights just the same as people who own homes, and this version of the bill carries in the language that we found problematic before. I would also just go back to the numerous studies that we've heard about in this committee and in others that show that residency restrictions do very little to protect children from sexual predators, as most offenses committed against children are committed by people that the child already knows. So with that said, thank you very much.
Thank you. Shelley Centerford.
Centerford on behalf of the Georgia Network to End Sexual Assault, and I too was not planning on speaking on the bill, but on behalf of all the rape crisis centers in Georgia, we want to express our concerns about adding these residency restrictions back in. I won't repeat what Ms. Tatanchi said, but given the fact that approximately 90% of child sexual abuse victims know their offenders, and approximately 75% of them are actually related to their offenders, there isn't any evidence that these kinds of residency restrictions will reduce recidivism or make victims safer. We'd be delighted to work with this committee on some proactive measures to provide treatment for offenders, to provide education about sexual abuse, to hopefully prevent it from happening in the first place, but we respectfully submit this isn't the appropriate way to promote victim safety and eliminate child sexual abuse. Thank you.
Thank you very much. Representative Levitas.
Mr. Chairman, this was going to be a question really for Ms. Michaels, but I guess I'll just make it quickly in the form of a statement. I guess I would disagree with the assertion that we cannot as a legislature make the photographing of any individual a crime. Whether it's strict liability, criminal intent knowingly is up to the legislature to decide, and I don't agree with the assumption that we could not criminalize the conduct.
Thank you, Representative Levitas. Chairman Knox.
Again, for Legislative Council, with respect to the current language in 18 and 19, I don't really know what the changes were on the other substitute. But in this case, if you took a photograph of some adults in a park and there's a minor child in the picture, is that individual, and they happen to be somebody on the registry, are they in violation of this code section then?
Somebody that's registered is taking a photograph, and within the photograph is a minor?
Yeah, it could be. The adults could be walking through a park, and there could be 3 children playing as they walk by, and the photograph's taken. Or they may be children that belong to, somebody else that happens to wander into the photograph. How are they exculpated, where it wasn't the purpose to take the picture of the child, they just happened to be in the picture at the time the picture's taken, or if you're taking video or something?
Well, a strict reading would suggest the answer to your question would be yes. Obviously, there would be some prosecutorial discretion that you'd have to rely upon in that circumstance, but strict reading is you have to have the consent of the minor's parent who's already.
And a further question, Mr. Chairman. In the previous two paragraphs, or at least in the previous paragraph on 2, we qualify no individual who is a sexually dangerous predator, and we didn't carry that. Why don't we include that in D as well, since we've already defined who we mean by an individual, but we qualified it further by saying sexually dangerous predator. What, am I looking at the wrong one?
No, that's how it's worded.
Oh, okay. Why don't we qualify this as, or was it our intent not to make this only sexually dangerous predators?
The way this code section is divided up is there are some restrictions that require every person that is registered, and there are some restrictions that apply to a sexually dangerous predator. A sexually dangerous predator is a higher echelon, so to speak, of predators, and it's defined in 42-1-12 for that article, and that person is the person who's designated as a sexually violent predator between July 1, 1996 and June 30, 2006, or who's determined by the Sexual Offender Registration Review Board to be at risk of perpetrating any future dangerous sexual offense. You'll recall when House Bill 1059 passed that you made the distinction.
Okay. So this is only in here because we're talking about the residence restrictions and distance restrictions. That's why you repeated it there, qualified it there, I mean.
In subsection C of this code section, that's a distinction of where people can work.
Right.
And there's a different level of restriction depending on whether you're just registered and whether you're a predator.
Okay.
That's why that language is divided out in C, and you'll see in B it's not divided out. B is where they reside. C is where they work. D is photographing. E is not divided out. That's loitering. That's the way.
Okay. All right. Thank you, Mr. Chairman.
Representative Bearden.
Thank you, Mr. Chairman. I guess the question would go to the senator or legislative council, because I think I heard two different answers on the same question. If you're at the park, and we use Chairman Knox's example, and if someone's taking a photograph of their parents and a child in the background is riding a bicycle, that's not intentionally. So line 18, where it says shall intentionally photograph, since that was not intentional, would not be a violation, correct? Because I swore I heard someone say yes, it would be if it was strictly read that way.
And I guess the scenario I was envisioning was this is a group photo and there's intentionally a minor in there. I didn't see the bicycle in the background.
Well, I put it in there. I just was going off Chairman Knox. If there was I thought you said a minor in the background, like walking past or on the bicycle or something. So I just want to make sure, because shall intentionally was the two key words I was looking at.
That actual wording,
okay,
Representative, was added by Senator Reid and the minority party and the Judiciary Committee, and then it passed unanimously, because I do think you allow the prosecutorial discretion if there's a picture of adults and there's a child over here, and if he's not using it for, I say he, but if the person is not using it for indecent purposes, then nobody's going to prosecute him. But if he's zoomed in on that child and has blown it up, then the DA's got the ability to go after that person and say it was intentional.
Okay, I just want to clarify that on the answer. Thank you, Chairman.
Representative Mangum.
I think my question was just, thank you, Mr. Chairman. I think my question was just answered, but you actually used the words when you said prosecutorial discretion, that the prosecutor would not prosecute them if they did not use the photograph for indecent purposes. Do you just really have an adamant aversion to the words indecent purposes on this language?
Yes, and the implication was that I had agreed to the changes that the committee made last year, and that was incorrect, and it was really why we held it in rules. Look, this whole bill, this 908 that y'all have worked so hard on, makes assumptions. You tell people where they can live and where they can work. Why can't we make the same assumption that the photograph is going to be inappropriately used? I mean, this is no different than the whole rest of 908 that y'all passed out of the House.
Further follow-up, just very briefly. So your purpose is that they don't need to take pictures, period. I mean, there should be no photography, because if I want to take a picture of my my son on a football team, under this language, is my understanding, it will be prohibited.
No, without the consent. It doesn't even say written consent. The police arrest somebody, and they've got pictures all over their walls of young children in compromising positions. Remember, they don't have to be nude. I mean, the Cobb County situation was they're sitting on the floor in shorts, or they're bending over, which whatever.
Right.
I mean, these are deviants. And if they see a bunch of these, then they'll say that, you don't have consent for that, or you'll go back to the parent of that child and say consent. If the person on the list has a picture of their niece up on the wall, they'll go to the niece's parents and say, did you give permission for this? And they'll say yes. Or they'll say no, because remember, a lot of these cases still involve family members. I mean, that's where a lot of child abuse comes from. So that's where we say consent of the minor's parent. And I think that would be the question between law enforcement and the parent or guardian of the child.
Further follow-up, just real briefly. If someone has pictures of kids all on their walls, and I mean, to me, and I think the jury would have to, to decide the community standards, but that would be for indecent purposes if they have no nexus to these kids and they got them all up. But you're now telling someone to guess whether or not they have the legislative intent, I guess, and I'm really.
But you've done that.
For the purpose, I am for no sexual predator having any pictures for any sexual, these indecent purposes, basically. And I'm just concerned that the scope that you are now placing, it's not very clear the intent of what you're trying to do. If you're trying to say you do not take pictures, period. And that's basically what I see a head shaking. That's what you mean?
Yes. I mean, one paragraph above, you've said they can't live within 1,000 feet of where minors congregate. You didn't add in there only if it's for indecent purposes. And I'm asking you not to do the same thing to photographing children.
I don't want them to have the picture even if they didn't take it. And I know I'm opening Pandora's box for someone else that's probably going to say, well, why did you bring that up? But if I didn't take the picture, but I get the picture and I have it up for indecent purposes, I think that's a problem. And I'm suggesting that you really don't want them to take a picture, period, because they may take it for an indecent purpose.
I don't want them to take pictures if they're on the if they've been bad enough to be on the sexual registry. I don't want them taking pictures of minors without permission of the parents.
Okay.
Or guardians.
Now, does this capture, and I think the question was asked and I got lost on it, does it capture the distinction between a real sexual predator versus those people who, when they were 16 and 15, were on the registry? It does not make that distinction, does it?
If they're on the registry, they committed aggravated child abuse, I believe. I'm not a lawyer, but so I don't know all of the distinctions, and I'll trust members of this committee to do that.
Our society is going to crap. I mean, it's almost like Rome. I read the statistic today: 1 out of 4 young women have had an STD. That means they didn't get it by being a choir woman or whatever. So I don't think we should just lock people up when they don't really have an intent of doing something. Oh, gosh. If 1 out of 4 of our teenage young girls right now, and the number was higher for African Americans, unfortunately, if they have an STD, they did not acquire the STD.
I may not be a lawyer, but I don't think you get on the sexual registry for having a sexually transmitted disease.
No, my point is that there are people out here having sex, and you are now, we can capture them and they can have a crime for doing something that was technically consensual, which I don't consent to, but we are making and I think we have to have some standards in our community. And I'm just suggesting that it's a very harsh thing when I am now 40 and I married that person, by the way, when we were 15 and 17, and now I can't even take pictures of my own basketball team or football team or anybody.
I believe you come off the registry after 10 years, and that you can apply to be let off the registry. could be let off the sexual registry list.
I won't badger you because, Senator, I think I really am more for you than I am against you, but I really do think that it is preposterous that we're going to be wasting resources on putting people. Oh gosh, I'll let someone ask questions. Thank you.
Representative Mangum, Representative Benfield.
I waive.
Representative Abrams.
I'll waive until appropriate time.
Okay. All right. Any further questions for the author? Chairman Franklin, you had asked to be recognized.
Representative Abrams actually asked before me, but I was going to ask to be.
I'm sorry, you're right. I'm going to turn your mic off. Representative Abrams.
I'd like to make an amendment to lines 18 and 19 to strike.
Let's, if I may.
Certainly.
I'll come back to you.
I appreciate it.
Okay. I'm sorry. All right, Chairman Franklin.
I move do pass by substitute LC 293366S.
All right, now we have a motion to give Senate Bill 1 a do pass recommendation by the version you have before you. Is there discussion on the motion? Representative Abrams.
Thank you. Now at the appropriate time. I would like to make a motion to amend lines 18 on page 2, line 18 and 19, beginning at the word without, strike through to the period, and replace that with the word for indecent purposes. And I'd like to explain my amendment for two reasons. One, I think Senator Johnson actually pointed out a very important statistic for me that raises a separate set of concerns for me. Parents and family members often are the sexual predators that have the ability to take photographs of their children. I think including the ability for a parent to give consent for the taking of that photograph is problematic. And because we're talking about the largest population of sexual predation, we give them the ability to opt out of this provision. I think that's a dangerous thing to do. In addition, I think that the language for indecent purposes captures the appropriate group of folks and provides not only the prosecutorial discretion that we've spoken of, but also does not unfairly capture and unduly capture, because I think intentional is a fairly vague word. And although we all, and even in this room, we've come to a few different decisions and conclusions about what constitutes intentional, my request would be that to protect the minors that we're intending to protect, saying for indecent purposes is an important language distinction, and at the very least we should not allow a parent to give consent for the taking of a photograph under the construct of this law.
Objection to the amendment. Author object. Any member of the committee object? Got an objection to the amendment. Representative Benfield.
Just very briefly, I'm sure we're aware, this committee voted that language out last year, and there is precedent. I'm just looking at the current code section on the state sexual offender registry, 42-1-12, subsection 10A X uses enticing a child for indecent purposes, and of course there's code section 16-6-5. So for indecent purposes is found in the code, and I think it is appropriate here to not unintentionally snare someone who's photographing adults and a child happens to dart in the background, and that's certainly not the author's intent, I know.
Representative Setzler.
Thank you, Mr. Chairman. While we're discussing the amendment, again, I share with the author an interest in advancing this. I guess my concern is that we and again, I apologize, I've been having terrible nosebleeds all day. If I need to stand up and walk away, I might just have to do that. I apologize to the committee. I have to do that. Excuse me. Pardon me, Mr. I'll be back,
Mr. Any further discussion? Okay, Chairman Cooper.
To the author, Senator, Representative Abrams brings up a good point that I hadn't thought about before, and you objected to the amendment, but I mean,
and I can recall several of these cases where, unfortunately, a wife has basically let the molestation go from a husband, and there would have been the photographs and so forth, and would have basically given her permission. What do we do then? I was not concerned until they brought that up, but then I can remember a couple of cases where that's happened. How do we cover that so we don't make a mistake in this?
I was actually trying to be sensitive to people who do have families that are on the sexual registry list, and assume that under very minor circumstances where the parent might allow a sexual predator to photograph their child. Most of them are aunts and uncles or ex-husbands or something like that, and they know good and well that they're dangerous and wouldn't grant permission. So I was, if you want to eliminate without the consent of the parent and just say they can't photograph a minor, that takes care of your concern. But it also would say that an individual on the sexual registry list who is has a legitimate family and has a niece or a nephew or a daughter couldn't take their picture.
I'm really torn. I wasn't trying to disagree with you.
But I'm trying to answer the question.
You did. Thank you. I don't know what to do about it. Thank you.
Representative Abrams.
Just to follow up on that question, I think the necessity of including the language for indecent purposes is important because we will capture people who are not under the language of this bill otherwise prohibited from engaging in businesses that require photography. I think that there is absolutely the need to recognize that parents and guardians can give permission for sexual predation to take place, and if the intent of this bill is to stop taking photographs of minors because it will lead to indecent use, I certainly understand that within the confines of this bill, but if we're going to do that, I think we need to be very particular and very specific about this. I do believe that allowing for consent, for a parent to consent to the photographic molestation of their child is inappropriate, or even to participate in that. But I think that by including the language for indecent purposes, we reach the same ends, which are that we were going to allow prosecutorial discretion for intent. I think the same can be said for indecent purposes. And indeed, as Representative Benfield pointed out, we have language in our code that describes what constitutes an indecent purpose. And so I would very strongly urge that if we do strike through the consent language, we include the indecent purposes language so as not to over-capture folks and to overreach, but to also meet the author's intent of stopping the use of these photographs, which may be decent on their face, for being used for indecent purposes.
Okay. Representative Setzler, you did not ask to be recognized, and if you don't wish to be, I won't. Okay.
And I apologize to the committee. I've had almost unstoppable.
No apology needed.
Today, so, I would just ask, I think in the spirit of the author, I don't know if we would want to expand the language simply to say no individual shall intentionally photograph or maintain a photograph. I don't know if they could obtain photographs of a child that they would use for indecent purposes, even if they didn't take it themselves. I don't know if that's even needed. But I think if the committee's, I would just share with the committee if there's concerns with this language, there are other ways to skin the cat, if you will. I would certainly side with the author in maintaining it as is. But I think we're trying to establish that a photograph that's maintained by a sex offender is prima facie evidence of an intent to use it for indecent purposes, and I read this language as doing that. So if it needs to be worded differently, then maybe something the committee would consider, but I think the spirit of the author is that we not have this burden that the state would have to prove that the photograph was taken for indecent purposes. I think that if anything, the burden should have to be on the accused via prima facie evidence that it's being used for indecent purposes, so that the burden doesn't rest on the state to prove that the photos were for indecent purposes. So I offer as a friendly amendment at the appropriate time, or maintain a photograph of, unless that's not necessary. I would withdraw that. So.
All right. Well, we have one amendment to deal with, and then if you still want to be recognized here in a moment, I will. Representative Collins, did you wave off? Okay. All right. Any further discussion? Any further discussion? Representative Mangum seconded your amendment, motion to amend, I think. All right, we have a motion to amend that we're going to take up first. This will be the Abrams amendment that is opposed by the author of the bill. Any further discussion? Hearing none, all in favor of the Abrams amendment, please raise your right hands. All opposed, raise your right hands. Okay, that amendment fails. Representative Setzler?
Mr. Chairman, I would just offer a friendly amendment.
Tell us where it goes and how you want it in there.
It would go between photograph and A on line 18, so that line 18 on page 2 would read, no individual shall intentionally photograph, insert, or maintain a photograph of a minor without consent of the minor's parent or guardian. Simply adding the word or maintain a photograph of.
Does everyone understand the proposed amendment? Is there a second? Is there a second? Do you have a question? All right. Final call for any second on the Setzler amendment. That amendment, or proposed amendment, dies for lack of a second. All right, that gets us back to the main question now, which is the motion to give a due pass recommendation. Is there any discussion on that motion? Any discussion? Hearing none, all in favor of the motion to give House Senate Bill 1 a due pass recommendation by the committee sub in front of you, please indicate by raising your right hands. All opposed, same sign. And that amendment, that motion has been approved. Thank you very much, Mr. President Pro Tem.
Thank you, Mr. Chairman. Appreciate the patience of you and your committee.
Thank you. Okay, Senate Bill 350, Chairman John Wiles. I appreciate you allowing the President Pro Tem to go ahead of you today. I'm sure he appreciates that too.
He is President Pro Tem and he is the senator from the first, so he always goes first. Thank you, Mr. Chairman, members of the committee. I just found out earlier today that I've been requested to carry the indigent defense bill that you authored that came out of this committee. So
all right, would you have a motion on this bill here? It's a heavy load.
It'll be an interesting debate. It'll be an interesting debate. Mr. Chairman, members of the committee, I bring to you Senate Bill 350, which is a bill that simply makes it an offense to drive without ever having been issued a driver's license, the same as driving on a suspended license. I'll say that again. Without ever having been issued a license, it makes the penalty the same as driving on a suspended license. And it makes it a felony on the fourth offense to drive without ever having been issued a driver's license or having had a suspended license. This bill passed both the House and the Senate last year, and it was called Senate Bill 15. The amendment to make it a fourth offense was actually done on the House floor. Representative Bearden did a great job, and it was a lot of struggle. We got it to the governor, and the governor vetoed the bill.
What was his reason?
His reason for vetoing the bill was
public reason, publicly stated.
The cameras are on. So his reason was that the language in the bill he was afraid would catch the new residents of Georgia. We had an amendment on the floor of the Senate which we thought addressed that, but he exercised his prerogative to veto the bill, and so I bring you back Senate Bill 350, which was drafted by the governor's office to the governor's lawyers, which provides a clause in this bill that says if you show up in court at for a first offense with a validly issued Georgia driver's license, the charge is dismissed against you. So that means someone that has moved in from New Jersey who has failed to comply with existing Georgia law, which says you've had to have a driver's license within 30 days. You go down, you get stopped, you're told you need to have a Georgia driver's license, you go to DDS and you get a valid Georgia driver's license, the charge is dropped. There is a real reason that we want everyone to have a Georgia driver's license that lives in Georgia. We cannot keep up with their driving habits if we do not keep up, if they do not have a Georgia driver's license. If people drive on out-of-state driver's licenses in Georgia, their offenses may not be reported back to their state. And so we will not know if we have a repeat offender. So there is really a reason we have this existing law. This bill, for those that don't remember, the reason I brought it is December 31st of 2006, Deputy Lauren Lilly of the Cobb County Sheriff's Department was driving to work. He had an accident, and he was killed in the accident by a driver who has since been convicted of driving without a Georgia driver's license, who is now in prison. Deputy Lilly's widow would have been here today, but she was out of town on business. We do have some other witnesses. It's a very serious crime, driving without a license. We spend an enormous amount of time down here regulating how people get driver's license. Think about it. We tell 16-year-olds what you've got to do. We have fine add-ons so teenagers will get driver's licenses. We spend a lot of time telling people what will happen if you lose your license. But what happens in Georgia is there's a substantial amount of people, be they licensed or unlicensed, who have either lost their license because it was suspended or never got a license, that repeatedly drive over and over and over again. Actually, after this crime occurred, one of my friends who is a city judge said, you need to fix this. You truly need to fix this. And she explained to me she had an individual in her courtroom who she found guilty of driving without ever having a driver's license, fined him $750. He walked out of the courtroom. Her deputy went out the back. He was getting in his car to continue driving because she didn't impose a jail sentence. And the officer said, well, you are now going to jail because I just saw you enter a guilty plea, and he got arrested. But that was the first time he went to jail. So it simply says 2 days in jail on the first offense. And the offenses go up. This is a bill, like I said, that was approved both by the House and the Senate. I had an article that just came out in the Gwinnett Daily News, or Gwinnett Daily Post, I apologize. Gwinnett County is now arresting 14 people a day for driving without driver's licenses. My city of Marietta, when the ones that provide securities in my son's sporting events, I was talking to him, and he said he arrests 1 to 2 to 3 a day. And these aren't these are not stops. These are not roadblock arrests. These are accidents usually. He said it's usually an accident. People don't have insurance. Somebody's hurt in an accident. And he says, let me see your driver's license. They've never had a license. You're going to hear a lot of opposition to the bill, but I do want you to listen to one of the victims of someone that was driving without a license. She signed up to testify. It is a serious problem. And I just think that repetitive violations of state law need to have an accelerated punishment. If you can't stop your behavior at a certain point, we're going to have to put you in prison. And people say we're making it a felony in the fourth offense, but you repeatedly violate state law. At some point, you're just going to have to say, okay, we're going to put you in prison. As a prosecutor, one time I told somebody that. I said, well, because your husband's being convicted of his 7th DUI, we're going to put him in prison. And she said, well, he got his 6th in the county jail. That was back in the old days in Cobb County when we had a county jail, and the guy he actually was driving a truck and got a DUI. So, sometimes people don't get a message, but I think you just got to say you're going to have to go to prison. One of the things I would ask the committee's indulgence, and I apologize to Representative Golick. He had come to me early. As you know, his better half is also a traffic court judge, Division II judge in the state court of Cobb County, and she came to her representative and said, I want you to make sure that DDS keeps a record of the people who drive without driver's license. One of the real problems is identifying those who have done it repetitively. My bill provides that upon conviction, now that's very important because at the hearing I had in the Senate, people got up after me and said, oh, we're going to fingerprint everybody that gets charged. No, it's only upon conviction you're fingerprinted, and only upon conviction your nationality is verified. and that's as a result of the Treaty of Vienna, and I can't remember the year, but someone else can probably give me the year, that requires us, when we incarcerate people, to verify their nationality. It's a treaty obligation in the United States. But Representative Golick has House Bill 1288 that he introduced, and he asked me to bring it in, and I did not get a committee substitute done, but I want to tell you about it, and we could provide it to Jill. And working with Jill on Senate Judiciary, she's been pretty good about this, and I've given it to Representative Levitas. About what we'd like to do is incorporate her bill as an amendment, his bill as an amendment to my bill. The first part of his bill simply says, any court having jurisdiction over traffic offenses in this state shall report to the department the name and other identifying information of any individual convicted of driving without a license. We do. Here's the bill with the marks on it, and I tried to make copies, but I found out that one of the talents I do not have is properly copying. Some of the things are upside down.
Do you need you just need one page?
Well, it's the first. We need section 1.
I do better when I look at it.
I understand. Yeah, I understand, Mr. Chairman. Section 1. Yeah, we need the whole bill, and I got out there and I was running your copier, and I should have asked for help. But I can come back and talk about the amendments. But I want to kind of explain the concept. It's one big code section, but it's only changing, just using the word individual, and that's important because under Georgia law right now, DDS only keeps records of licensees. They try to create a record of John Wiles without a driver's license, and then the next person that turned up would be Jonathan Wiles, but they don't have any cross information. DDS, Representative Golick has talked to DDS, and they said they have no problem with including this language in the bill. They want to have this identifying information. Department of Driver Services wants to be able to identify people who are repeatedly breaking Georgia law. And I apologize for the late amendment, but he caught me as we came in, and I tried to do best, and I'm not really good at that. But in closing, I would really urge the members of the committee to consider this as a very serious matter. People are dying in our county. After I introduced the bill last year, before the governor vetoed it, 2 more of my constituents were killed on 75 by a person who has been convicted of driving without ever having had a driver's license issued. People are dying in Georgia as a result of unlicensed drivers, and I would urge support. And as always, Mr. Chairman, I'm very glad to answer questions.
Okay, why don't we? You've got a number of questions. Let's go ahead and deal with those, and we'll come back to the amendment. Chairman Knox, I think, had asked first.
Mr. Chairman, I would like to be recognized for a moment. Yeah, easy for me to say. I'd like to be recognized for a motion at the appropriate time.
I'll come back to you. Secretary Bearden.
To the author of the bill, just want to make sure people understand driving without a license. We're not talking about someone who has a license and goes to the store and leaves it at home. And I think that's something key, and you try to hit on it a lot when you testify. I think it's just very important to hit on that again. This is someone that's never been to get a driver's license at DDS before.
That's correct.
And that's
I've had some help, and I didn't say it clearly enough last year. That's why I said without ever having been issued a license. There is a separate crime in Georgia, which is driving without a license on your person, and that's a very small fine. And if you show up in court, most of the time you waive your license. They say go and send no more. That's a different crime. We're not dealing with this. You've never gotten one from the state.
Thank you.
Mm-hmm.
Representative Kevin Levitas.
Thank you. I'm glad you distinguished me from the other Levitas on the committee, Mr. Chairman. I want to.
There are other ways I could have referred to you.
And I think you probably had those in mind, and I think I better stop while I'm ahead. First of all, Mr. Chairman, I want to commend the author on his excellent testimony regarding repeat offenses, especially in the area of drunk driving, and I want it clear for the committee I in no way paid him any money to make that testimony here. Mr. Chairman, at the appropriate time, I will also have a motion to include the amendments that the author is requesting.
Chairman Wiles, I think you'll be hearing about a bill from Representative Levitas if you haven't already.
I have, Mr. Chairman.
I sort of thought that was the case.
It'll get a good, fair response from me.
As always. Chairman Franklin.
Mr. Chairman, since we've already heard this bill before, and the governor's already weighed in, and everyone knows how they're going to vote, at the proper time, I'd like to be recognized for a motion to also include the Senator's amendment.
Okay, I will come back to those that have asked to make motions, but I will say, Chairman Franklin, and I think you would agree with me, that this committee is not preempted by any other branch of government. We're an equal branch, and there are some minor changes here, and so I want this committee to have a full and fair opportunity to look at the bill and ask questions about the bill. Well, all I said was equal. Representative Abrams. Representative Setzler.
Hey, Mr. Chairman. Again, just in the name of caution, I strongly embrace the spirit of the bill. I do have a question for the author on page 2. And to the author, my senator from Northwest Cobb. The provision for first conviction and the fingerprint piece, would a person that was accused be able to find a way around this if they were not convicted? But, and again, I don't know how these proceedings normally go. This is just, again, I don't live in the courts. If they pleaded no contest, is there something procedurally they could do to get around a conviction where they did it, they couldn't present evidence to the contrary, but somehow the conviction's still not brought, such that they could avoid the fingerprinting? Because I want to make sure we can still make sure they're getting in the system and in the process.
That I don't believe they could, and maybe Legislative Counsel Jill can help us with that. I think a conviction, a nullo contender plea is considered a conviction, but maybe she can help. If I could, Mr. Chairman, I defer to her all the time. So
we have a little rule here. Jill can answer if she wants to, and if she doesn't have to.
Yeah, I know.
I thought generally it was.
Yeah.
It's not. Well, hey, we got an expert here. Would you weigh in on this, Mr. Spahos? Thank you.
Several times within the code, I'm sorry. Several times in the code, specifically a NOLO is called a conviction. So I agree with Jill. If you don't call it a conviction, it would not be one, because there are several times. In fact, later in this code section, on page 3, it specifically says for this subsection, a NOLO shall constitute a conviction. So absent that language, I would think you would have a problem with it.
So, but I think because the language.
Well, it refers specifically to the subsection.
Okay.
So you have to go back and refer to the entire code section.
Yeah, Mr. Chairman, my intent on this is to the author is that a NOLO plea would be the same as a conviction for the first offense and the fingerprinting and that getting into the DDS system. I want to make sure that's.
And I, Mr. Chairman, I would absolutely agree. The key to here is tracking to make sure we know somebody's doing that. So if we have to, if Ms. Travis is so inclined to comment as to what the appropriate words would be, it might be simply on line 6, upon a first conviction or plea of NOLO contender. Yeah. No, let's see. It does say upon a first. Doesn't it say? She has offered an amendment. She says on line 9, right after the word obtain, or a plea of NOLO contendere accepted, is accepted. Yeah, that would probably be appropriately not something I would offer to the committee, but someone else, maybe a member of the committee, could offer that as an amendment also. That's what I thought, but if Ms. Travis has a concern, I'm willing to. I want a good bill. With all due respect to the committee members, there are a lot of smart criminal defense lawyers out sitting behind me right now, and we're going to, smarter than I am, we're going to make sure we get it as tight as we can.
Did that take care of you?
Well, Mr. Chairman, that was my question. I would like to try to get resolution on that. I don't know if this is the appropriate time or if we should.
Well, the amendment hasn't been offered. I mean, if you want to work on the amendment, I'll be happy to come back to you.
I would just ask the chair, is it something I should formulate? Is it something, can I ask legislative counsel to make a recommendation if either okay or would need to be amended? I mean, is it okay as it is, or do we need to?
I think that you're going to have to add language about the no-no.
Okay.
But the way I'm reading it is for which a conviction is obtained.
Yeah. I would ask the committee if at the appropriate time, I would accept that as a friendly amendment, Mr. Chairman.
Representative Setzler, if you want to take a moment maybe and get with Ms. Travis and come up with some language, I'll be happy to recognize you for that amendment.
Thank you, Mr. Chairman.
I think we're in agreement that it needs to be amended. Okay, Representative Abrams.
I have a question within the same section for the author. If you look at lines, and actually I can wait for Jill if you'd like, because it's another legal question. On lines 9 and 10 in that same section, it strikes me that reading this section A in tota, you're saying that if you do a plea of nolo contendere, you are still you're still subject to punishment for not less than 2 days, even for a nolo plea. Is that the intention of the author?
That is the intention. If you drive without ever having had a driver's license, or you drive on a suspended license, you understand that is the current law. It's the existing law. We're just adding in driving without having had a license.
Okay, thank you.
Further questions for the author? Further questions for the author? Are you getting close, Representative Setzler? We don't have a motion yet, so I'm not quite ready for you. That's right, we do. I'm sorry. You can take your time. I'm sorry. Representative Lunsford.
Thank you, Mr.
We're
Chairman.
pleased that you could be with us today.
Thank you, Mr. Chairman. I had obligations elsewhere in the Capitol for a little while. I apologize for being late.
Your solicitor's been wondering where you've been.
Yes, sir. He pinned me and reminded me of this meeting while I was in another meeting. I do have a question. I came in late. If the author could address it for me. I see on page 2, line 9, where the person for which a conviction is obtained shall be fingerprinted, shall be punished. I'm okay with the fingerprint part and shall be on page 2. I assume we're working off LC 2930-34?
We are.
Okay. My question is this, and I apologize for being late. I was actually covering another meeting, but is there any mechanism within this bill, without me reading through it completely, because by the time I finish, y'all probably already made your motions, so that if someone is pulled over who possesses no driver's license, and currently I believe that what we do is we post a cash bond and let them out, and the solicitor could probably correct me if I'm wrong. Is that correct, Mr. Solicitor? Okay. Without fingerprinting. You're saying upon for which conviction is, but that person could be caught again driving without a driver's license. We don't have a fingerprint on record. We didn't have a proper identification state issued. How do we know we didn't already catch the first? Is there any provision in this bill to retain the fingerprints, to compare them as a John Doe person who drove last time without a license, and then now John Doe is driving again without a license, and prevent them from pleading nolo contender 4 times under 4 different names?
Unless you get the first conviction is the first time you get fingerprints under this bill. Now, some departments, it depends. The city of Marietta, if they arrest somebody, they fingerprint everybody they arrest. And that's just their policy. Some places do, some places don't. So if you got a conviction, you had someone arrested and you were the prosecutor, at least when I was a prosecutor, and the solicitor probably can correct me, you run the criminal history of the person that you're prosecuting. If you've got fingerprints, you could, the first time through, you could slide through. There's no, and this addresses one of the concerns. Last year, there were concerns by the governor's office. There is a little-known part of state law that deals with what offenses get fingerprinted and what don't. And it's a code section that, I'm sorry.
Now, if I follow up, Senator, here's my question, and maybe you can help me. Maybe if we can't address it today, maybe we can address it in the future, and that is that majority of these offenses key off of upon conviction. But the reality is that when you pull them over and they don't possess a driver's license, and they tell you they don't have a Georgia driver's license, realistically, and they post a cash bond, they're not going to come back for the conviction. They're going to forfeit the cash bond and not come back, because it's quite obvious that they are convicted the moment they come back, which means now we haven't fingerprinted them or we haven't retained it. is there not some mechanism that we could work within the agency so that that fingerprint is attached to a alias John Doe, and next time that person is automatically fingerprinted with no driver's license, we find out the alias John Doe had driven before?
We hadn't been able to figure it out, and that's for any crime, though. If you have a burglar and he leaves his fingerprints, if you arrest him, you'll get his fingerprints. But if the arresting agency chooses not to fingerprint, or you understand, a lot of these go out on citations. Many places don't arrest people who are driving without. They just go, here's a citation, appear in traffic court in 90 days.
Do any of them ever show up, you think?
Okay. And perhaps that's why, at least in one of my municipalities, they arrest everybody.
I'm okay with that.
Well, it's just, but that's local control to that they can choose to and choose not. And some have changed how they handle arrest of drivers without driver's licenses. But I really can't figure out a way to fingerprint somebody and to pre-arrest, pre-conviction. This was the way that the governor's office, and like I said, there is a provision, and it's very complicated. It's almost they sit down and try to explain it to me, where they and the GBI decide what offenses go into the fingerprint registry, and it's a state law, and they make like an administrative decision. I don't know if the GBI is here or not. The AG's office. It's the AG's office that makes the administrative decision as to who gets fingerprinted, and that's as far as I can go on my knowledge. You've now run me over the edge on this one.
Mr. Chairman, could I follow up one more time, and then I'll be quiet, or try to be? I got a question, and maybe I can ask it of the AG's office. There's not a method by which we could say, if a person's pulled over in the state of Georgia, and they're pulled over not possessing a driver's license, and state to you they don't have a driver's license, they're automatically fingerprinted. That fingerprint is established with a number, like a barcode. It's put in GCIC as a barcode, not as a person, but as a barcode. And the very next time someone's pulled over and doesn't have a driver's license, you fingerprint him again, and the barcode matches. You may not know his name, but he will be in jail. And we are done with that person driving without a driver's license again. That is a really simple fix. It would the same method they use in a retail store to keep you from shoplifting. It's got a little barcode that rings the bell when you walk out the door. We don't know the person's name, but we know there's a number on that package. Well, Mr. Chairman, we may just solve this problem. I'm glad you said that. I have a little language here. I was leading up to.
My problem is with all due respect, the executive of the state, and I know that we have our beliefs where we are in the pecking order, and he has. I think this language is his language that I negotiated with them to avoid what happened last year, and I would support a standalone bill, but I really don't want to continue to let unlicensed drivers go to Georgia because the bill gets vetoed again. Because that was a concern that the AG brought to the governor's office, and I could never find a happy medium. And maybe we got to find a happy medium in another piece of legislation, but I just can't. We could never work out the parts, and I'm afraid it would end up the same place it ended up.
You're not suggesting, are you, that if one of the members of this committee could find a complete solution for the problem, that would somehow be a step back from this bill?
But I got 92 votes last year in the House, and I didn't get a veto-proof majority in the Senate this time either.
Indulge him.
I indulge him.
Indulge Representative Lunsford. He has more solutions than anyone I know.
Mr. Chairman, I guess I lied a moment ago. I have one more question. If you would indulge me for a second. And I think that there is a method under today's technology, without being onerous on any particular person, any nationality, etc., where we have the ability today to fingerprint and establish an identification number of that fingerprint. Forward that fingerprint with that identification